All right, today we're going to be doing the minimizing liability training, where we discuss some kind of key areas of risks and liability, especially pertaining to residential sales. That is where almost all of our complaints, lawsuits, issues, upset people have come from. And so I really want to try to cover some areas that have come up through complaints, and also other areas that I've researched and learned along the way. And hopefully these will prepare you for any issues that may arise and also potentially avoid them, which is ideal. All right, so first of all, early required documents and prep. So, number one, representation agreements with the NAR settlement that happened, they are required on all residential sales, and leasing on the tenant and the lease listing, as well as the buyer and the listing side. Make sure you are using the correct rep agreement and situation. We have all of them filled out in sample form in the Agent Portal Classroom. We also have a representation video in the Agent Portal Classroom as well, of which we will be updating that one as well. There's two other documents that historically I haven't required, but I am requiring effective January 2026, which is the wire fraud warning, which is provided by the Texas Association of Realtors. 2517 is the call number. This warning will help protect your clients in an event that they're targeted for a scam. And if they fall for it, believe it or not, but if they decide to send, $100,000 deposit to some scammer who's posing as a title company or something, they historically have decided to go scorched earth because that money's gone. They feel bad about what happened, and then they start to figure out what they can do to recover that. And so they sue the brokers, they sue the title company, they sue you, they sue everybody. And our E&O insurance, the regular E&O insurance does not cover wire fraud. Now we went ahead and beefed up our insurance coverage to include a cyber protection rider along with that. So there is some protections available in the event of wire fraud, but I really don't want to have to rely on insurance. What is better is if we just provide them the warning up front. Whenever they sign a representation agreement, they should also be signing a um, wire fraud warning, a general information sheet, as well as the IBS. All of these should be in that first discussion whenever you're getting them signed up. And that extra warning, that extra protection does help protect you from those types of litigation because we provided a warning. We let them know about this danger, and then they succumb to it anyways. General information, the Texas Realtors 1506 is kind of a catch-all. I mean, it talks about disclosure notices, talks about warnings, it talks about a number of things that both buyers and sellers should be aware of going into a transaction. So providing them this, while it is not absolutely necessary, again, it's just like a catch-all notice, like, hey, we provided this notice to you. The fact that you didn't read it is more on you than it is us because we gave you the warnings. Um, and then make sure the seller is the property owner. This is actually a TREC complaint that happened recently against an agent that I sponsor, and the seller just went straight to TREC and filed a complaint. The actual owner of the property, sorry, filed a complaint because they noticed that their property was for sale online. Um, and instead of just contacting the listing broker and the listing agent to figure out what the heck's going on, they just filed a complaint with TREC. And so we were contacted. Now, prior to us being contacted by Trek, we were already contacted by the local police department, found out that there was someone impersonating the owner, and we took down the listing immediately. And so that did save us. It ended up being closed out. But, that's still an important note to make because if this sale or transaction had got further down the road and people put down earnest monies and spent money on feasibility to find out if this property is going to work for them, there's money at stake. There's money that's been spent and lost on a transaction. So what's better is if you get a lead from someone that you do not personally know, this lead is internet sourced or just a call in or something like that, get a copy of their DL or get hop on a Zoom call and see them face to face. Go meet them in person at the property. And then on top of that, verify with the tax records that they do in fact own the property and have the ability to sell it. Because if it's owned by, say, a trust, and they aren't the trustee, then or the executor, then they don't have the authority to sell that property. There may be other recipients that would be involved, and there could be another issue if you move forward. So there was also another situation where I received a call from Channel 4 News about one of the agents was trying to sell great grandma's family house that's been in the family for 60 plus years. And the like aunts and uncles were all up in arms and found out, you know, later that this thing was under contract and they were trying to sell it. And the great grandma had dementia. And so they felt like this agent was taking advantage of the great grandma. And we had to do a little bit of research and we found out that great grandma was still married, husband was still very much alive and fully cognitive and had authorized this transaction. So it ended up being okay. But, it was kind of like a pretty close call in that sense that we needed to really kind of dig in and make sure that there's not going to be any issues in selling a property. If your client is someone who's cognitively impaired, then you need to make sure that whoever that guardian or if the spouse is still alive is you're hopping on the phone with them. You're talking to them and they have authorized this transaction. Okay. So related party disclosure. This is a recent policy change that we put in there. The contract has a related party disclosure, but it's very minute. It just states that there's a conflict of interest. And that is what this is considered. If you are selling a property that you have some financial interest, whether now or in the future, say there's a chance that you could inherit it, immediate family, or if it's a property that you're investing in, or a property that you personally have, owned, then as the agent for that property, you have some conflict of interest there because you understand the inner workings of the transaction. And then in addition to that, there are disclosures that need to happen. There are things that some people who may not be 100% honest may omit or forget to add in. Um, Whereas if you are representing someone else and you send them a seller's disclosure and they don't really know all the inner workings of the business, they just fill it out to the best of their knowledge. And then on top of that, that arm's length distance between you and that person gives you protection so that if they forget to disclose or choose not to, whichever is the case, then they're taking that liability on themselves. Whereas if you are the agent and you forget, that omission can become a bigger issue. And in addition to that, insurances don't like to jump into situations where the agent has represented themselves. And there's some that will not actually step in and cover a claim on a lawsuit for something related to that. So what's better is, we just fully disclose everything. We created a related party disclosure that goes through really a lot of the aspects of the liability with selling a property that you own or you have financial interests in. And it lists all of those out and it makes it very clear that you have nothing to do with these. The brokerage has nothing to do with these. I would highly encourage you guys to go into the agent portal classroom and give it a read. Um, or actually it's just in the agent portal, sorry. But give it a read and then understand the terms that are in there because that is where the liability lies. That is where things can happen and we can get into significantly more trouble where our insurance may not be able to step in and help us out. So, um, you need to be vigilant about making sure everything is properly disclosed and over communicated to minimize the risk. That related party disclosure, that's what helps with the over communication. We want to be seen as honest and forthcoming with whatever may be an issue with a property. And every property has at least one issue. Everyone, even brand new properties, they have issues. So we want to disclose over, we want to get it all out there because anything that's not disclosed comes, that turns into a problem later on becomes a problem for the agent, the brokerage, and the seller. All the parties get looped in. Um, the other thing is development. So again, whenever if you have a client or that is related to you, maybe a family member or it's an investment that you have financial benefits from that is purchasing properties or develop and fixing them up or developing brand new properties. This is development. Now, these development activities are typically isolated to the business that's doing the development, typically. However, whenever there's no arm's length between you, the agent, and the developer, that's where we have issues. So if there is arm's length, it's a family member or a business or something like that, then we have a three-party development agreement that includes, the client, I mean, you, the developer, and me, um, or at least the brokerage and the client. So that way we're making it abundantly clear that you as the agent and me as the broker have absolutely nothing to do with the development of this property. And it includes the developer in that agreement because number one, they're being asked to add the brokerage and the designated broker as additional insured to their builder policies. In case of, we do end up getting sued for some property that they developed. And then on top of that, if they are developing a property that maybe, you sourced or something like that, you're staying the heck out of the development procedures and whatever, you know, they're doing on their side of it is completely separate from what you're doing. All you're doing is the real estate agent activities. There's no picking out floor plans. There's no, picking out paint colors and or helping with contractors or doing any of that stuff because as soon as you cross that line, as soon as you get over there and you're involved in the development of that property, or if you or your spouse are doing development, then there's no arm's length, there's no protection, and you, the brokerage, and the designated broker can all be held personally liable for the activities of the developer. Anything that that developer did that screwed up on, that made a mistake, whatever, we can be held liable as well because there's no arm's length between the two. So, make sure that you get that related party developer agreement signed if there's any financial benefit from a developer. And make sure you get the related party disclosure signed if you have a property that you're, selling that has a related party or you have some financial interests in the future or now. All right, next, copyright infringement. Got to learn about this one as well. Insurance does not cover copyright um, lawsuits. It doesn't, intellectual property, it does not get covered by your typical E&O insurance or general liability. As a matter of fact, they have exclusions specifically for those. So we did go out and, like I said, we beefed up our insurance. So there's some areas of copyright that are covered, but there's other areas that are still not. So first and foremost, make sure you don't use anything that could have copyright implications without the owner's written permission. This could include property floor plans, photos, internet videos, internet photos, articles, even using AI could use copyright information and provide it to you, and you don't know. So anytime you use an LLM or AI to produce some type of marketing material, make sure you cross-check it with another AI, whether it's Gemini or Perplexity. Perplexity is really good at cross-checking across, the internet and copyright and stuff like that. If you plug in what was generated and say, hey, could you check over this and make sure there's no copyright implications for this? And it will tell you. It'll let you know, like, oh, actually, we found this on this site, and it pulled this information from here. You don't have, and it is copyrighted, so you need to get their authorization to use it. These are things that are very important because while most people will give you a heads up like, hey, you need to take this down. You don't have authority to use this. There are a few businesses usually that already have in-house counsel, and that in-house counsel has to make money somehow, and their job is to find where their copyrighted information is being used. So instead of you getting a heads up, we'll just receive notice of service of a lawsuit, and you will be sued, I will be sued, everybody gets sued, and there's usually a settlement involved because if you get sued for using somebody's copyrighted material, you could be held not only responsible for your own legal fees and defending it, but also the plaintiff's side legal fees. And if they've got some hotshot lawyer that wants to drop $100,000 bill on you, then that judge can very easily just say, yes, they're the ones who copyright infringed upon this plaintiff, so they need to pay these. Not only do they need to pay 5x whatever damages they decide, but you also have to pay legal fees as well. So just don't even go there. If you are creating your own content, great. If you're using content that's online, that's royalty free, great. If you're using content that's online that costs a little bit of money, pay the little bit of money. Do that because it's better to have the authority to use those than to just use it from whatever you found on Google or through AI and get in trouble for it. And if you ever have any questions about, oh, should I use this? Call me, text me, email me, whatever. And then we can look into it as well for you and help you know what's safe and what's not safe. But if you take something that's been out there and alter it, make it your own, be creative. Don't just add an asterisk in the top right of the picture and expect it to be not copyrighted. No, it doesn't work like that. If you go in and you genuinely modify it and make it different, but you use the original creative to get off the blank page, that's okay too, but it needs to be noticeably different. Okay. All right. So, promulgated contracts and addendums. As an agent, we take a lot of risk helping people purchase homes. As a matter of fact, there are a number of states where the agents aren't allowed to help fill out promulgated forms, contracts, any of that. There are a number of states that whenever it comes to the contracts, the client has to get an attorney. As a matter of fact, in Texas, for commercial, almost all commercial transactions happen whenever there's an attorney involved. Now, if it I will say that, there's some areas of commercial where that's not necessarily the case, like office rentals, Regis and stuff like that. That is very much like apartments and stuff. You just go in and you're just working directly with the management company that's there, but they usually have an in-house attorney that's written up the contract and designed it to help protect them. Where that differs from here is that Trek and TXR attorneys have put together these promulgated contracts for us as agents to use. Now, we do not have license to practice law. As a matter of fact, that's one of the big things that Trek is really hard up on, is about making sure the agents don't practice law without a license. And that could include filling out the hang on one second. Sorry about that. Someone came to my door. Um, okay. So the promulgated contracts that were created by these attorneys are um, very important to understand because they're buyer beware documents. They're not designed for like even protection on both sides. As a matter of fact, the contracts have a whole slew of stipulations, clauses that help the buyer back out. The addendums are almost always created to help the buyer to be able to back out from the transaction. There are no, addendums or clauses within the contract that state that the seller is able to back out. As a matter of fact, there's only one way that a seller is technically allowed to back out, and in the seller termination form, that one is the earnest money must be delivered within 72 hours. However, if they don't, and let's just say they don't deliver the earnest money in the 72 hours, but they deliver it on the fourth day, the before the seller termination notice is delivered, that contract is valid at that point, because the earnest money was delivered prior to it being terminated. So one thing you want to discuss with your sellers is that they need to be prepared to sell it, no matter whoever they sign that contract with. Anyways, so I digress. The promulgated contracts and addendums, the key points that you need to understand are, the correct forms are being used. Make sure you're not adding language to a form. This is practicing law without a license, that especially if there's already another form dedicated for that. I've seen people write in the other modifications or the special provisions of a contract, X amount of dollars will be paid to the buyer's agent as the commission. There's already a clause in the contract specifically for commissions. Um, and I've seen a number of, clauses written in where there's already an addendum that's created for that particular clause that was written in. So that I review all contracts that come through, and I've seen it all really. And these types of things happen, and that can get you into some trouble because this is considered practicing law without a license. The the forms need to be completed properly. Make sure you're filling it out, in which the means that you're taking the liability if you do something, if you fill it out wrong. So whenever you fill out something, you don't want to accidentally put in, 120 days for approval on a particular, clause or something like that, because that could be or actually I should say, since it's like a buyer clause and you're representing the buyer, and say for the third party financing addendum in the approval section, if you put 5 days for approval and then they don't get approved, then they don't have the ability to back out because it's past that 5 day mark. So you want to make sure that you're filling out things correctly so that one, these clauses are made available to your client, and two, you're not taking the liability on yourself by improperly filling it out. So anytime you have a question about a form, if you don't feel right about how it's being filled out, send it to me. I will review it. I will provide you feedback. Another good area or resource for you is the legal hotline, the TAR legal hotline. They have a legal hotline available for realtors. You can call a number and it will ask for your license. It'll verify that you're a member. And then in addition to that, it will be able to, provide you some legal advice. Now, they are not going to give you certain details that might construe representation. They are not your attorney, but they can give you some help whenever it comes to situations that could occur, and then also some help regarding promulgated forms and how they should be filled out. Um, Time is of the essence. I'm sure y'all learned that in some of your training. Everything has a clock on it. So it should be done within a timely manner. Delay on your part is not you don't want delay on your part to be the cause of the issue. Make sure anytime a document is delivered to you, that you shoot them an email, a text message saying received, because there's actually a rule that says, I think it's either 24 or 48 hours as an agent, you're required to notify them receipt of any contracts that have been sent. So just shoot them a text saying confirmed, received, got it, send it to my clients. How simple is that? But by not doing that, you're in violation of those um, rules that are placed on us. So just, let them know. And if you haven't, let them know as well. Say, I know you said you sent it, but I don't see it in my inbox. I don't see it on my phone. Can you please resend it? Communication, over communication, make sure that you're staying on top of those things. And then the same is on your side from you to the client. Your fiduciary is to act as the best in the best interest of your client. Their best interest is to know whatever information you know at when you know it. So if you're provided a document or information or something in particular about the property that they're looking to purchase or lease or whatever, then your next step should be communicating that information to them, providing that documentation to them. By removing yourself from the equation, by being a conduit of information, that removes you from the liability. You've done your part. And then whoever is at risk is the parties, not the agent who was just the conduit. Um, the promulgated contracts are buyer beware. We have no backout clauses for the sellers. This means promulgated contracts should be seen as a buyer's contract, and the responsibility performing primarily lies on the buyer side. I mentioned earnest money. I guess I jumped slides here, but the buyer must terminate and cite one of the valid clauses listed in the contracts and addendums, and it must be submitted to the seller in writing within a time specified. Now, what I will tell you is that most title companies they're like Switzerland in regards to staying neutral. They will go out of their way to stay neutral. They will not issue out earnest money back to the buyer or to a seller, especially without earnest money release form being executed by all the parties. Typically. Now, the one exception may be option. If the option period's being exercised, then it should automatically send it, they should automatically send it back to the buyer and there shouldn't be any issues. However, even though the contract stipulates in other areas, like say they weren't approved, um, it stipulates that the earnest money will be returned to the buyer. I've seen a number of title companies still require the earnest money release form. And if you've got some sellers that are sticklers, it can become a problem. So just make sure that anytime your client wants to cancel or terminate the contract, that you find a valid clause that's within the contract or addendums that's available still. Make sure you check the timing on it. And then utilize it, make sure it's cited and provided in writing within the time specified. You should know all of these times. So the buyer approval, you have up until 3 days prior to closing if they don't get approved according to the property condition. Like for instance, um, like it say it doesn't appraise. What a very common one is people are using they most of the agents here have stopped doing this because they've been educated, but that right to terminate due to lender appraisal is not for uh, you know, a property that's being bought from conventional financing and it just didn't meet appraisal. That's not the situation. The third party financing addendum already does that, and it does it better than the right to terminate due to lender appraisal. The right to terminate due to lender appraisal is in addition to the third party financing addendum, and it's usually if the property is being told it needs to appraise for a specific amount other than the purchase price. So, for instance, a partial would be, less than, say it's a $350,000 house or offer, and as long as it appraises for 300,000, we'll still buy it. This was a very common thing back in 22 whenever there was a crazy seller's market. This is when actually that uh appraisal termination form came out. Um, and then the other is you can have addition to, or you can have just full waiver. So if you say I'm buying it for 350, but it should be worth 400. I want it to appraise for 400. So you can put that in that form as well and use it for that. But you don't use it for the exact amount of the offer. This is a redundant thing and it causes conflicts with the third party financing addendum. And then the other is just a full waiver. You're just saying in that right to terminate due to lender appraisal, you're waiving your right to terminate due to lender appraisal because the third party financing has a right to terminate due to lender appraisal built in to the property condition. This is a very common way that these addendums have been misused. But anyways, so just make sure that you understand the timelines on each addendum that's being used, each clause within the contract, particularly around like seller's disclosure, option periods, title. Uh, these are very important clauses that are available to people, to your buyer, um, that you need to already know. Or if you have a transaction coordinator, they may be giving you a heads up, like, hey, they've got 3 days left on the title commitment to terminate if they want to. All right, so the buyer must purchase the house on the date specified in the contract, or the contract is voidable. It's and no longer enforceable. So these terms, I don't know if you remember them from your training, but it doesn't mean that the contract is no longer valid. It just means it is voidable, meaning you could go fight it out in court and probably win, but you're going to spend a few $1,000s on attorneys getting there. Um, and they may not be able to enforce, the seller may not be able to enforce it, or no, the buyer may not be able to enforce the contract, the terms in the contract, if they decide to close after the closing date and they haven't extended the closing date. Now, with that being said, I've had this happen a number of times, but there's no black and white rules whenever it comes to a closing date. As long as the parties are acting in good faith, that contract is fine. The house can still be sold. Title will still go through with it. If it doesn't close on the date specified in the contract, that doesn't stop title from doing what they're doing. If, it's supposed to close on the 31st and it's the 3rd, and the buyer, maybe there was a delay with the appraisal, And that's what caused a delay with the closing disclosure, which has to be provided 3 days prior to closing. So it ended up being pushed out till Wednesday of the next week. This is a very common thing. Do you need to get an extension? If you want to offer be able to give your buyer um, additional clauses to be able to back out, then go ahead and extend it. If you want that contract to still be enforceable, go ahead and extend it. If the parties are still acting in good faith and planning on closing, and maybe the seller just says, I don't want to sign an extension, let's just see what happens. We'll just close if it's going to close. That's okay too. Show up at title on Wednesday at your closing time, sign the documents, and funding will go through and the home will sell. If the sellers decide not to go sign, you guys acted in good faith. If it ends up going in front of a judge, the judge is going to be like, what's your problem? To the sellers. You signed a contract, you agreed to sell the house. The buyers acted in good faith, and something happened that was out of their control, but they did everything they could and they showed up to closing. Maybe it was 3 days late, but they still showed up. So that is where it can get real sticky. So anytime this type of situation happens, give me a call. I can totally, talk you through and help you navigate that situation. Okay. We did just kind of cover some of this, but I want to reiterate. Sellers are all in. If a buyer does not perform on a specific situation, um, they cannot terminate or back out. Um, they could face expensive litigation. And what I will tell you is that if a seller or your client has a bad experience buying or selling a house, it's going to be associated with you. So while your fiduciary is to your client and their best interest, you don't want to go die on a hill. Don't Sometimes being right can be wrong. Meaning like they may the one of the parties may not be following the contract to the letter of the contract. However, if you can help set expectations and navigate them through a situation to where the home still sells, it closes, and everybody's happy, you did a good job. But if you decide to, you know, dig your heels in and you embolden your client to do the same thing, then at the end of the day, if they're having to go through litigation and hire attorneys, this was a very bad experience for them. And they won't want to do it again. Or if they do it again, they won't want to call you and bring you into it because they're going to associate those together. So just make sure that you're, helping people understand the possible outcomes, the things that they need to be aware of. Now, if a buyer performs according to the contract, the seller has to sell. They don't have a choice not to sell. Now, a court will not take away a homestead from a seller, but there could be some expensive liens and judgments that can come on that seller if they decide not to perform their side of the contract. So if you have a seller that's wanting to terminate, you need to, one, set the expectation before they get into the contract. Like, hey, once you sign this is it. You're in it to sell it no matter what. Number two, if you get into it and they decide they want to sell, I mean, to terminate, say, unfortunately, you don't have any clauses to be able to terminate. We've passed the earnest money period. We're in it, and there's no clause for you to be able to back out. What you can do is, negotiate with the buyers and perhaps pay them off to go away to terminate the contract, but the buyers would have to terminate. Um, the sellers, though, are not obligated to do anything besides sell the house on the date they agreed to. This is a very common thing as well, where say a buyer puts in a contract and then during the option period, they decide to bring in a dozen different contractors and then they send over some ridiculous list of things that the sellers need to repair, a seller can say no. They don't have to fix any of it. They can say no to all of it if they want to. And then the buyers, they have to decide, okay, do I want to exercise my option and back out, or do I want to accept what they said? Because they can't force the sellers to fix things. It's very common for agents to, freak out whenever they get a list for their client, who's the seller, of all these things that they need to repair, and the client freaks out, like, I don't want to pay to fix all this. As a roof, a new HVAC, it goes on and on. The answer is, well, you can just say no. You don't have to say yes. What I typically tell my clients, or whenever I used to do it, is if it's FHA or VA, there are some items that have to be repaired prior to closing. That is a government subsidized loan, and they have minimum requirements. Anything to do with the mechanical aspects of the home, like plumbing, electrical, HVAC, or structural, brick, facade, roof, foundation, any issues that are related to those have to be repaired prior to closing, or they won't um, back the loan. They won't authorize the loan. The sellers won't be, I mean, the buyers won't be able to buy it. Sellers won't be able to sell it. So anytime I see those items on the list, I tell the clients, like, hey, these are pretty important issues that do need to be addressed. What some contractors will do is, if there's enough equity in the home, they'll do the repair as long as they have some type of, agreement that states that they'll be paid at closing, wired from the title company or something. I've had a number of foundations get repaired that way. But anyways, those things are there. But anything that's like cosmetic, for instance, like the windows, the little mist inside of them where the seal's been broken, that's a cosmetic thing. Sure, it may have decreased our value a minute amount, but to replace, 10 windows in a house could cost $10,000. Especially if all of them have, were poorly sealed, or it's on an older home that those seals have just gone out. The answer could just be no. I'm not going to replace those. If you want to replace them, you can buy the house and replace them yourself. Um, okay, let's see. They do not have to negotiate, don't have to negotiate expenses or other unexpected costs that have arisen, but the buyers could terminate. If they agree to provide a seller disclosure or survey, they should. The buyers could terminate. You should get the point here. Like, the sellers need to perform according to the obligations that are in the contract, but there's no obligations to repair things unless if it's already in that part of the contract where it says we'll buy it under the condition of these repairs being done. If the buyer does not perform one of the specific obligations, earns money on time, the contract is valid until terminated by the sellers. All right. So why does all this matter? As the agent, whether the buyer or seller's agent, you need to understand how to manage your client. You got to assume all of them are ignorant, that they just don't know. Maybe it's their first home, maybe it's their fifth home, but there's a number of people that don't have any idea of the issues that could arise through a home sale. They may have sold 3 homes without any issue, and then all of a sudden they're trying to buy a house that's being sold by someone who's foreign, and they're learning about back with, withholding taxes and stuff. So just make sure you protect yourself. Set those expectations with the clients and help them understand what they should be doing going into the sale of the contract, sale of the home. You need to know how you should be performing, and pushing them to act according to the contract that they signed. So any of the terms that are filled out by the buyer's agent, and you sit down with the client, you know, ask them to read through the contract and let you know if they have any questions about anything that you filled out. If they have any questions about any specific clauses and what they mean in particular, they really should start talk to an attorney because understanding the terms and clauses that are in a contract uh, is really important for them. But at the same time, you're not an attorney, and explaining a contract to someone is considered practicing law without a license. So there's a very fine line there. Say, for the option period, you say, we put 10 days for the option period and it's $150. If they want to, and the example of that is, so if they come back and say, okay, why did you set $100, $150? Well, that's a pretty common amount. It could be different, and the seller may come back and want $200. I don't know, but those are, terms that we added. But if they say, well, what does this option portion of the contract mean? What does it mean exactly? Well, that clause allows you to be able to back out of the contract by paying this amount within this time period. And if they want to understand it more than just your basic and just say, I'm not an attorney. I'm really not qualified to explain the clauses in a contract. If you want to, you can contact an attorney and find out more. Um, so just, adding that little stipulation is just extra protection for you. And as far as like knowing when to perform and pushing them to act is usually done through like a checklist. I have a residential contract checklist in the agent portal classroom that has deadlines for option period, title commitment, third party financing, HOA, all these different very common deadlines that they need to understand, um, that these deadlines expect them as a buyer to perform and sellers to perform. So, if you have that contract, if you have that checklist available to you, you can set reminders on your phone, set reminders in your email, because you can't expect your client to remember to do these things. You need to be the active one, the active participant in each of those deadlines. And the reason why is because if they forget to, you know, terminate within the option period, maybe they waited a day late because they misunderstood the contract. Their ignorance is your fault. That is how it's seen. So they will not think of themselves like, oh man, I screwed up. I messed up on this. No, they're going to be like, well, the agent should have explained this better. Why didn't the agent contact me and let me know that the option ended on Friday at 5 p.m.? Why didn't they tell me it? Even though it clearly states in the contract, it doesn't matter. They will look at you as the reason why that clause didn't come through. So overperform in those deadlines and make sure that they're aware of those approaching deadlines and be prepared for them, especially like the option period. What I would usually do is if we still haven't ironed out the negotiations and it's the last day, that morning I'm sending over the termination to my client to sign. It's only valid once it's been delivered to the other party. So I just have it locked and loaded so that if we don't get it back or we don't get maybe an extension to the option period, then I have the ability to terminate and keep my clients safe. So it's already prepared and you're not waiting on a signing at, that afternoon and the 5 o'clock deadline is approaching. It's better to already have it and have it ready to go so that when that time comes, you can send it without any delay. Your performing requirements. Okay, so confirm receipt of contracts. We talked about that as soon as possible. Send them a text or an email saying it's received and it's being sent to the client. If you're not using a transaction coordinator, then you're expected to make the client aware of the deadlines. I just talked about that. Any discussions you have should be documented by a follow-up email covering the content. This is a general, like, protect yourself action, otherwise known as a CYA, but I won't, go into how the acronym breaks down. The thing that I'm talking about is if you have a phone call, whether it's no matter who the party is, maybe it's the other agent, maybe it's your client, especially with your client. Anytime you have a phone call with them and anything related to a transaction has been discussed about what to do, what should be covered, what should be done, anything like that, send a follow-up email that breaks down what the discussion covered and tell the clients on the phone call, say, hey, I'm going to send you a follow-up email that just covers what we discussed just to make sure we're fully clear on everything. What this does is one, it timestamps your discussion. If there's ever a Trek complaint, you can be like, well, the afternoon of the 23rd, I had this discussion. Here's the follow-up email that I sent that covered the topics of that discussion, and they received it at that time and that date. So that timestamp and date stamp is going to help protect you and back you up in the event of a complaint or a lawsuit or issue. Um, this is, across the board, you should be protecting yourself. Anything that's verbal is non-enforceable. You guys know that from your trick training. So just make sure that everything that is discussed over the phone that you think could potentially turn into an issue at some point in time, if it even has the outside opportunity to, you should send a follow-up email just to have just in case. Other areas of risk. Involving yourself only in tasks that require license, meaning don't call and order vendors for your client. If they're needing some things done to their house, um, don't be calling up your buddy to go do the roof or to go do the flooring or something like it. You can provide them referrals and let them call and hire and manage that contractor client relationship. But you getting involved means that if they didn't do a good job, the vendor, the client's coming after you and the vendor. Now, Trek has said that we can't be held liable. That doesn't mean we can't be sued, though. It's better if you just provide a number of referrals and let them figure it out. Because if you get involved in something that is not a licensed activity, mind you, that you're adding liability on yourself, you're adding liability on the company as well. Don't perform repairs yourself or upgrades. If you want to go help, move some boxes or clean because they're a friend or a family member or someone from church, that's fine. I'm not saying that. What I'm saying is if they've got some electrical issues, don't go over there changing out plugs, especially a licensed activity like that where it requires a licensed electrician, because that risk is being put on you and the brokerage. If that electrical fails and burns the house down, and I mean, worst case scenario, someone gets hurt or killed, then and it's tied back to the outlet, you're getting implicated. The brokerage is getting implicated. Don't put yourself in that situation. Stay with the transaction. So don't get involved with issues with the property after the closing. Man, this happens so much, especially with uh like seller temporary residential leasebacks. Man, I hate those. I absolutely hate those because it's it's all risk and no reward on those things. Um, Once a temporary residential lease goes into effect, the house is sold and that seller is still there and that buyer bought the house, that is no longer a sales transaction. You're done. You sold the house. Your job is done. You don't get involved anymore because it's a property manager tenant issue. If they move, if they're having issues with the house, if the sellers have an issue with the house while they're tenants, and they decide to go after the property manager because of something they did to the property while they were tenants, let that be their problem. Don't get involved. The same on the other way, like the buyer side. And then with leasing, once that lease is signed on like a residential lease, once that lease is signed, your job is done. Anything else after that is property management. And you are not authorized to do that because it's all liability, all risk, no reward. If they call you saying, hey, this place is infested with roaches, man, that sounds terrible. I'm so sorry. Have you contacted your property manager? No? Okay, give them a call. They'll be able to get some pest control. You did and they didn't answer. Oh, I'm sorry. If you go to the county appraisal district website, you can actually see who owns that property and contact the property owner. You can find out who owns the property and let them know the property manager's not doing a good job. You know, go do something with them. Don't get you involved. That's what you don't want to happen. Don't call up vendors and try to, send a pest control company out there to fix the situation. Don't call up the utility company to help them get utility. It's just that's property management that's going to get you in trouble, and it's just not worth the risk. All right, let's see. If no resolution can be made, they need to contract an attorney. You can recommend that. Other parties can include title companies, issues with title companies, inspectors, appraisers, sellers, buyers, property managers. It- those are their problems, not yours. Don't get involved with those. Careful what you say. So, under promise, over deliver. I mean, this is sales 101. If you make a statement that you're going to sell the house within 30 days in a buyer's market, then you're setting yourself up for failure because you don't know what buyers are thinking about that house. Instead, say, look, I did a CMA. The average home takes about 60 days in that neighborhood to sell. It's a buyer's market right now. Given, these circumstances, we should expect somewhere between 60 to 90 days to sell the house, but there's no guarantees. Just saying no guarantees. You're setting that expectation. You're letting them know not to expect anything different. If you set an expectation that is hard and fast and you don't meet that expectation, then you're a failure in their eyes. They're ready to fire you, they're ready to move on, and they will not recommend you to other clients. Um, and then if you educate your client the risk of each decision so that there's understanding and proper expectations, if you aren't sure, tell your clients. You will check with your broker. Man, this is such a key, important thing. Like you don't ever claim to know everything. I don't ever claim to know everything. But what I do is if someone asks me a question I don't know the answer to, I say, let me get back to you. I'm gonna see what I can find out. Because I know people, I know title companies, I know lawyers, I know AI, chat GPT, I know the internet. I've got a wealth of information at my fingertips. I can find out that information and get back to you. Do that. Don't just shoot from the hip. Don't guess. Don't um definitely don't elaborate. Instead, say, let me get back to you on that. I will help you. I will tell you exactly what I find out. No property management. We talked about this. So number one, we don't offer property management as a service, but also no property managing your own or your spouse's properties. If you own a property or your spouse owns properties that they are property managing, historically, I used to allow this as long as it was in a separate business, but come to find out, there is no separation there. If you or your spouse own properties that y'all are property managing, that is considered a licensed activity. And if one of those tenants knows or finds out that you are a licensed agent and say you leased them there, and you put down the broker's name or something, they will sue you. They will sue the brokerage. They'll sue the owner of those properties. They'll sue all of it. And there is no separation. We can't come back and say, oh, well, they're owned by this brokerage. They'll just say, well, one of the owners is a licensed agent and they're held by this broker. So a judge will say, okay, vicarious liability, y'all are all included in this lawsuit. You're not able to be separated because there's no arm's length distance between the two. So if you have owned properties that you're wanting to be managed, have a property management company manage those properties for you. And that way they take on the risk and liability for those property management activities. No helping tenants. We just talked about this. There's risk in helping people after they're already under a lease. It's considered property management, and you could be held liable as a property manager, even though you're not getting paid for it. It's called implied agency. So as acting as that agent, then you can be held liable as that agent. It's not worth the risk. All right. So how to reduce the risk? Make the client aware of the risks and how they should decide to not follow the contract or not perform. So if they decide they're not going to do something in a contract, just make sure they understand the risk. They're the ones who get to decide. You don't decide, they decide. Just make them aware. Say, look, if you decide to do it this way, just know the buyer may back out. They may terminate, or the seller may sue you if you don't do this. Um, Take the clock out of their hands. If something needs to be submitted to the client for signature or to other parties, make sure it's done as soon as possible. So the delay is not the reason for the issue. If you're unsure about which document to use, contact me or the broker, designated broker, whoever the leader, the brokerage is. You need to contact that supervisor or document prepper, whoever is the one that oversees documents, and make sure that they are aware of your question, and then they can tell you. Put that risk on them because they're the ones that's their job to teach you anyways. Any transaction where the client or other realtors being difficult should be raised to the broker for mitigation strategy, meaning if you start to see the train coming down the tracks, if you think this thing's starting to get off the rails and it's bad, the people are upset, it's starting to look like it's going to go the wrong way, call us, call the broker. Uh, the we don't like to be surprised by the other party saying, "Hey, this agent's doing this." Call me, text me, say, "Hey, I've got one that's starting to go a little sideways. What do you think I should do?" We'll hop on a call. We'll discuss the situation. We'll talk about mitigation strategies, and then you'll know what to do going forward. I'm telling you, like half the calls I take, the agent was about to do something critically wrong to make it get a lot worse. So it's better to talk to someone who's been through a number of issues and been able to navigate those, in an effective way and find out, get someone else's perspective that's not emotionally attached to the transaction. Even as an agent for that transaction, there is some emotional transaction because there's money involved. You have commission that is at stake. You may have a client that you're related to or know personally. There's emotions that are involved. Get someone who's not emotionally involved in the transaction. Tell them what's going on and then work out what to do. Okay. And then um, make sure everything's in writing if there's a risk present, which is almost all the time. So phone calls, do a follow-up email covering the conversation, have everything in writing will protect you if a claim or a lawsuit or something like that comes up. If a threat complaint or a lawsuit comes up, the first thing you need to do is sit down and write down a timeline of the events. You should have text messages, email copies, um, and then paragraphs. Write down how each conversation went, what was the date, what transpired, what was the outcome. If you can like have a chronological order of everything that happened that led you up to that point. Whenever that lawsuit or track complaint comes, you're already prepared. You can provide that as evidence. You can sit down and be able to say, all right, this is what we did on this day. This is what we did on this day. And this is how, it turned out. All right. Um, Tar Legal Hotline. Here's the phone number with questions about promulgated forms. It's free. It does not cost a realtor any money to call the legal hotline. So anytime you're having issues, especially if I'm not able to answer right away, still shoot me a text, I will follow up with you, but you can call the legal hotline as well and sometimes get it resolved really quickly there. The residential contract checklist, which is available in the agent portal. This is a great like schedule timeline of how to keep on track for a transaction. All right, so that's it. Um, we ran a little bit over an hour, but it was a lot to cover. Do you guys, I'll go ahead and open it up for any questions that you may have.
I've got a couple.
Okay.
Um, do you believe in doing a pre-inspection when you're selling a home? When I sold my last house, I paid for that, and I guess it can be a time saver. And any thoughts on paying for a pre-inspection when you're selling?
It's probably a waste of money.
Yeah, because they're always
Yeah.
going to want to do their own inspection
There,
regardless. But
any agent that's worth their salt or any buyer that has any intelligence in them is going to do an inspection, even on a brand new home, even on a new construction. They should have a third party inspector come in and inspect all the aspects of that home because there's always issues, always. So whenever you're selling a home, one inspector to another could have two very different inspections. So you could get an inspection and fix, all the big chunks on there, and then get another inspection that maybe wouldn't have caught some of those other issues that weren't that big of a deal.
yeah,
Um, and you just paid for an inspection and paid for repairs that you wouldn't have had to otherwise.
do you believe in having or can you force a buyer to use the home warranty if you're like you're buying this house, we demand there be a home warranty and that it gets used?
You can't you can't necessarily force it because the buyer's agent is the one who fills out the contract. But
Hmm.
what you can do is say, hey, the seller really wants to provide a home warranty. Now, just know that the language that's in the contract states that the buyer is the one who gets to choose who the home warranty company is. So, all you're doing is saying, look, I'll throw an extra $500, $400, whatever on here and just have them pick a home warranty. And if you put it in the contract, the title company will usually put it together and get it, set up. And it does. We had a American Preferred Home Warranty is a company who we have like a related, you know, party with them. We work with them. They're affiliated agreement. So we have an affiliated agreement with American Preferred Home Warranty. And they came and they did a roundtable. It's in our agent portal, but they talk about in there that um, the home warranties actually started going away during that seller's year
Hmm.
because um, they didn't want to pay for that. They didn't want to pay for anything. They wanted to pay reduced commissions, all that stuff. And so what ended up happening was they said the next year there was an increase in E&O claims and lawsuits. And it's because, they didn't have some home warranty to come in and fix whatever issue that may have arisen. And they feel, the buyers, instead of, having some way to fix the issue that happened a week after closing and feeling like, oh, this wasn't disclosed. They lied to me. I'm going to sue them for this. Instead, they just call up the home warranty. The home warranty comes out, fixes the HVAC, and they move on, and it's all good. So it is good to certainly offer it, but I don't think you can like force them to.
Last question. If it's a desirable property and aren't kind of forced to fix things the buyer's requesting, is there a problem necessarily with just saying you guys want new windows and a new deck or repairs of this deck? I'll just pay for all this and put money aside at closing, and it's on you to hire whoever you want. I want nothing to do with it. Is there any necessarily problems with putting too many things into being paid at closing for repairs?
Um, where it gets sticky is like if it's FHA, or some government-backed
Yeah,
mortgage, they require those things to be repaired prior to closing. So you can't just negotiate and just pay a dollar amount. If it's conventional or cash, then you could certainly negotiate and just say, I see your list and we'll just give you 5 grand as a seller concession um, for those repairs. And the buyer can be like, sure, that's fine. The buyers almost always will just agree to, as long as the amount is something that they're agreeable to, they'll take the money and just do it themselves because the benefits of hiring the contractors themselves, they're able to oversee whatever repairs are being done versus the sellers doing it and the buyers just not liking what the outcome was.
excellent. Thanks.
Amy, do you have any questions?
No, I don't. Thank you, though.
Okay. All right. Well, this concludes the minimizing liability. I'll go ahead and post this up here shortly. Y'all have a great day.
Thank you.
You
You
too.
too.
Thanks.